It's good to have Fred back. He's going to talk today about free culture and Creative Commons, which is what he's been working on for the last couple of years. Really cool stuff. Friend of the class, Fred Benenson.
Hi guys. So, unless you skipped Monday, you've seen me before. So I hope I did a pretty good job laying the groundwork for kind of the next thing in copyright. Before I go any farther, did you guys have any questions or figure anything out that I missed or anything like that from the last talk? Yeah, I know copyright history and fair use can get a little dry, but this stuff should be a little bit more interesting. So, two things. Well, one, full disclosure, I work for Creative Commons. It's kind of my full-time job to kind of show up and give talks like this and talk to people who are interested in Creative Commons. So, in some sense, I am biased. But I'm also a member of Free Culture. As Evan said last time, I helped start Free Culture at NYU. But I'm also on the board of the larger national student organization. But I'll get to that. This talk is mainly focused on Creative Commons because I think it's kind of an interesting project that really ties into computers and society. But it also talks about kind of my activism and history in that. So Creative Commons is a nonprofit. This is our website as a month or two ago. Everything we do kind of runs off our website, but we offer legal and technology tools that allow people to share work online. So like, what's the point of this? Like, why do we get into this? And it's actually a really long answer to that question, but basically there's an inherent tension, which you guys probably tapped into or were aware of in my talk last time, is that the internet is this big copy machine. Copyright's designed to prevent you from copying things. And the law is still trying to kind of catch up. But there are a lot of people trying to do their own kind of catch up too. And so this is a screenshot from Apple's website. It says all rights reserved at the bottom. And if you kind of understood the basic premise of fair use, when you really think about it, all rights reserved might not make that much sense anymore. If I say, you know, I show you a photograph online, and I say all rights reserved to this photograph, I can do whatever I want, it's my photograph, you can't do anything. You'd say, hey, what about fair use? So this universal qualifier, I studied philosophy, all is the universal qualifier, is really broad. And so when Apple says all rights reserved to our webpage or whatever I grabbed this from, legally they can't reserve your right to make a screenshot about it or talk about it in, you know, a presentation or whatever. So just starting there, there's a tension, right? Like people, corporations realize the internet's kind of out of control in terms of copying, so they go like one step farther with this all rights reserved stuff. Sorry to harp on that, but it gets even weirder. When you look at the actual terms of service for some websites, they say they have really weird stuff in there. Like, this is from Apple again. You may not remove any proprietary notice language. I guess that's what that is. You can only use information for your personal, non-commercial, informational purpose. I don't think this is personal, so arguably I'm in violation of Apple's terms of service. And there's this larger question about what exactly I agreed to when I went to the Apple website. Like, I'm bound by this big legal document now, and you know, Apple will say just by visiting the site, you agree to these terms of service. And there's a larger, much deeper legal question over what this means and how enforceable it is. So there's this inherent tension in digital media. You have the kind of essence of a computer, which we can probably get into in class, where you have not only the ability, but kind of the easy ability to copy things. Every time you get a file, you can make a copy of it, for the most part. But this tension is further implicated by the fact that it's really easy to make derivatives, right? Like you can, if you wanted, throw an MP3 into a video pretty quickly and then upload that to YouTube. And you've suddenly made a derivative work that's probably infringing on the rights of the music holder who made that song. So, I mean, that's just one of 1,000 ways that you can easily make new derivative works online. And so, in reflection on how these technologies work and how easy and cheap these technologies are, you really start to wonder how in tune is copyright law with reality and technology. And I think the lawmakers and the government say, oh yeah, law takes a long time to catch up with technology, and this is something you're kind of reading about in code if you're there in Leslie's book. So Creative Commons really tries to tackle a solution for this. And so there's this big question that if you've come upon work online, what if you want to share it, download a copy, print it out for your friends, you want to remix it, build upon it, you want to even comment about it, sometimes fair use, like you saw in the Apple terms, like they would say I don't have fair use, it's kind of a weird territory. Or if you want to translate it, there's this whole swath of rights that we kind of don't normally think twice about when we use. Like if you want to translate a New York Times article for somebody, back home who doesn't speak English, then that's a arguably copyright infringement on the New York Times. And of course they're not going to go after you, but it's kind of silly that we have these really easy tools to make these things happen and communicate. But every step of the way, the law is telling you you're a criminal. And I'm kind of older than you guys now at this point. Every generation, it gets a little bit easier to do these things. And it gets a little bit easier to upload a video to YouTube or distribute a song. And that's not going to change. That's kind of an inevitable fact of how modern technology works. It disseminates through open cultures and open societies, and it's not going to stop. So what do we do about this huge conflict between the nature of copyright law and the way people tend to treat things online, right? The law and the copyright holders, the incumbent traditional media corporations, would say, well, you should just hire a lawyer and then we'll negotiate it, right? Like, sure, there's a price for everything, and we'll sort it out. You're a student at a university, you won't have to pay that much. Well, that's a little silly because A, money's entering into the fact, and B, you have to hire a lawyer sometimes, and that's ridiculous. If you're a musician, you want to use a track and remix it, and you're unsure about its fair use standing, the transaction cost, even if you have a lot of money, of hiring a lawyer and clearing the rights of a song can be extraordinarily high. And like I was saying with Girl Talk, there's this like theoretical possibility that he could spend the time and clear every one of the samples on that album. But it's not really feasible for him, and he doesn't have the resources to do it. And there are a whole other kind of set of questions of kind of the consequences of making people actually do that. So from a lawyer's perspective, and that's who started Creative Commons, the copyright law is in immense conflict with how people tend to treat culture, and that should never be how laws work, right? Law should be kind of a natural reflection of how we treat each other in reality or want to be treated. And there are things like jaywalking and speeding that are kind of functionally legal, but it's now that basically all parts of copyright are functionally illegal, and that there needs to be an update in a sense. So the basic premise behind Creative Commons is that you can get permission in advance to do these things, like translate, build upon a work, comment, share it, remix, and that kind of thing. So how do you do that? Like, what's the actual way that you can help people facilitate these transactions? Because a lot of you are going to be fine if somebody just wants to translate a work, but maybe not use it commercially, and so long as they say that you made it, or you're even fine with them using it commercially. You just want attribution. So Creative Commons is kind of based on these principles of sharing and remix that we kind of boiled down from how people tend to use media. So from left to right, we have attribution, share-alike, no derivatives, and non-commercial. These are 4 kind of basic constituents of a license that make up 6 different licenses. If you guys are good at math, you'll say that doesn't make sense. There's a lot more if 4 parts get combined into all of their finite possibilities. The one thing that all Creative Commons licenses share is attribution, so that knocks out a whole batch. So they all have the attribution requirement. And some of them are actually incompatible with each other. The right to remix a work, but you can't say you want people to remix a work but not remix a work. And so on one hand, where the attribution license says you're free to remix it, you can't then say you can't remix it. I'm getting ahead of myself. But from left to right, you have the kind of most liberal license to the most restrictive on the bottom. On the top, it's attribution only. You can apply this to a work. So you're free to use this so long as you give me attribution. This is what's also called a permissive license. And at this point, I should probably give you some background about this idea of a license, right? It's not really like a common thing to think about licensing work online, but you guys are probably familiar with Linux, right? Who doesn't know what Linux is? Who does? All right, so most of you guys get it. It's the kind of homemade operating system. But now it's become this kind of powerhouse in corporate America. It's a really valuable tool for developing your own products and software and not facing transaction costs when collaborating. But to kind of go back, what were the conditions that made Linux possible? A science graduate student, a computer science graduate student at MIT was working on a number of software projects in the 80s and frequently saw corporations come in and buy the work that he was doing from MIT and lock him out of his own work. This guy's name was Richard Stallman, and he's since become famous in the kind of computer science hacker world, and he actually gave a talk to this class last year. So Stallman was really annoyed that companies like IBM and Hewlett Packard would come in and buy these like little drivers for printers that he was making work around the office. And computers weren't like they are now, where you basically plug stuff in and it kind of works. I mean, Windows is a different story, but there's a basic premise that when you hit print, you get a document that kind of looks like what you were working on. In the 80s, it took a lot of work to get to that point, and it didn't really work ever that well. So Stallman was kind of like fixing up all these things, and all these software companies were like, hey, this guy's pretty good at this. Let's just like get it and take it and merge it back into our kind of like upstream software releases. So IBM was kind of just pillaging Stallman's work, to give one example. So Stallman realized that A, this wasn't fair, and B, there are kind of 4 principles for how software works that he felt he had kind of observed in his environment, and there were the things that helped him learn how to write software, and he thought they should be a part of every operating system, programming language, application on every computer. So these basic kind of freedoms, which he now refers to them, are the freedom to share, freedom to learn from the work, freedom to redistribute it, and freedom to modify it. So these 4 freedoms he saw at the core of all computer software applications, and if he could just instantiate these in some way, then he could prevent corporations from IBM coming and picking up the software and locking him out of it. He would say, no, IBM, I still have to be able to learn and kind of build off my work. And I keep on using IBM. I'm pretty sure it was IBM. They were manufacturing a printer, or maybe a computer that he was working on. It's kind of ironic now because IBM is one of the biggest free software.
The first laser printer.
It was the first laser printer. IBM is now one of the biggest free software supporters in the corporate world, but things have changed, and mainly because of Stallman. So Stallman needed a way to kind of make these kind of freedoms real and actually apply them to a work, and he came up with the idea of applying a license, but not a private one, but a public one to the software he was writing. So this kind of harkens back to the idea of the difference between source code and object code. Stallman didn't really care about object code because for most humans, it's even him, who's a brilliant hacker, object code isn't very useful. It's very hard to tell what was going on when you just look at memory allocation stuff. Source code, on the other hand, is what humans write and what computers interpret. And it's the kind of core of any application is source code. It's changing a little bit now. There's scripting languages like PHP, which don't actually have object code, but I digress. Stallman thought if he could apply those 4 principles to source code, and he could do it in the way of, in the form of a license, and say, if you come upon this work and you want to build on it, you can't prevent other people from sharing and learning the things that you did with it or that I did with it. So you can't co-opt my work. And this is the kind of impetus behind him creating something called a GPL, which is a general public license. The GPL is part of a larger project he was working on called GNU. And GNU is kind of a funny thing. It's a recursive acronym. And if you guys haven't encountered recursion yet, this will be your first introduction. GNU stands for, GNU is not Unix, right? So Unix was a really popular operating system for mainframe computers, and that was what was running at MIT at the time. And he was annoyed that he had to kind of do all this work around Unix, which was kind of a locked up system, and nobody really had the source code, and it was this really monolithic kernel. Kernel's the core of an operating system, but Stallman was so annoyed by Unix, he started a project called GNU is not Unix. And the G doesn't stand for anything but itself. And he just thought it would be funny to add a G on top of it so you could pronounce it like GNU. He then went on to name another operating system called HERD, which is a doubly recursive acronym. And I mean, it's just kind of computer nerd humor. But the GNU project contained a really important feature, really important application. And it was a free software version of the C compiler. So C is was the de facto standard for writing big applications on processors. And C is a programming language which, if you do more programming, you'll eventually come in contact with. And it's kind of a weird language now. It's a little antiquated, but it was kind of what people who were writing contemporary applications on computers were using. So one of the problems with C was that the basic compiler, the thing that took the source code and turned it into the object code, had bugs in it, and it was problematic, and it would crash, and it didn't do memory allocation right. And this annoyed Stallman. So he rewrote a C compiler from scratch. And that was the big thing, because then that enabled everyone else to kind of work on new projects and have total vertical freedom inside the software stack and development stack. I know this is getting a little technical, but the basic point was Stallman started on this mission to rewrite essential tools for operating systems and make them free. And he used the GPL, which is a public license. Yeah.
Well, I think the further point you didn't mention is that if you put something in the public domain, people can take it,
right,
make a derivative work, and then copy it.
Right. So if you just release, kind of, the larger point about the GPL is that it starts something called copyleft. Before we get to copyleft, the idea behind just releasing a work for free so that other people can learn from it is that IBM can then come again, pick up the stuff, make some modifications, and gobble it back up. And IBM has no obligation to give you the modifications that they made or let you have access back to your work. So Stallman geniusly came up with another recursive concept called copyleft. And copyleft is the basic premises that is embodied by his 4 freedoms. And it says, if you make modifications of this code, you have to release those as well. And this prevents IBM from coming in, gobbling up the code, and just preventing other people from having access to it. Stallman's essentially saying, this is kind of a quid pro quo. If I'm going to share with you my source code, you can't prevent me from seeing the changes that you made if you're going to distribute them. So copyleft was this kind of like nugget of brilliance in the software world, and allowed people to work collaboratively on a software project and not worry about anybody coming in and co-opting it. It means a bunch of people can start on a project and say, we're going to release this under the GPL. And so anybody else can come and work on it, including a corporation, but we're going to still have access to it at the end of the day because they'll be kind of bound by the GPL public license. So the public license actually applied to the copyright of the source code. And that's how this kind of has to do with copyright. Anyway, this is all to say that a lot of Creative Commons and a lot of the movement that I'm a part of now is really based off of the ideas that Stallman instantiated in the 80s. And we all owe a lot to him and his thinking about this. But he didn't take it all the way. By the early 90s, he was still working on his whole operating system replacement. It was called the HERD, and it was really problematic. An undergraduate software programmer in is it Norway, right? Torvalds? Finland.
Easy to say Scandinavia.
Northern Europe. Linus Torvalds was working on a kind of project that if you do more computer science, you'll come dangerously close to replicating. And he decided to take it a little bit more seriously, and he wanted to make a real operating system for 8086 computers. And that's basically an ancestor of this computer, but he wanted to write the entire thing from scratch, the operating system. And he basically got there. It didn't quite work. But at some point he was like, all right, I can't do this anymore myself. I need to open this up to the community of people that I kind of know are out there. So he posted something to Usenet saying, here's the code, it's not very good, it doesn't work, but it's under the GPL, so work on it. And help me, because I think this is an important project. So at that point, Linux was born. He used the GPL, which was kind of Stallman's idea and license, to license a more kind of compatible and functional version of an operating system. So Linus has been working on, yeah.
Wasn't it that it was based on GNU, and so he had no alternative but to release it under that license?
I think there are components. The kernel itself was what he wrote, and that was his contribution. It benefited from GNU, which is Stallman's kind of utilities, like a C compiler.
Because Stallman always makes a point that it shouldn't just be called Linux, but it should be called...
Right. So one of Stallman's mission, one of his many missions, is to correct people's usage of the word Linux, and it should really be called GNU Linux. Because the operating system that you download now and work on now is based on a lot of the utilities like the GNU C compiler and a text editor called Emacs and other kind of basic functional tools that were kind of cobbled together and put and accompanied with Linus's kernel and then released in what's called distributions. So have you guys ever heard of Ubuntu? So Ubuntu is a particular distribution of Linux that kind of has everything from Stallman's GNU C compiler to Linus's kernel. There's a lot of other free software in there, but most of it uses either the GPL or a permissive license like the BSD license, which is closer to the I license. So the whole point of this conversation is to introduce the next license, which is Attribution Share-Alike. The idea is basically the same thing as the GPL. The one distinction between us and the free software movement is that Creative Commons licenses apply to cultural works like video or photos or music, and not software, whereas the GPL applies to software. So Attribution Share-Alike, which is the second license on the left, is meant as a corollary to copyleft, but for cultural works. It means if you take a piece of music and you include it in a video, thereby making a derivative work, that video then has to be licensed under Attribution Share-Alike as well. You can't gobble up somebody else's work and then not let other people share it and build upon your modifications. So it's meant to kind of encourage downstream freedom. Some people call this viral licensing. Other people find that offensive because it's not a virus. But I just like to call it kind of reciprocal licensing. So anyway, after that, there's attribution non-commercial. This is more straightforward. There's no glamorous backstory to this one. It says you're free to use this work so long as you give me attribution, but you don't use it commercially, like reselling a piece of music or putting it in a car commercial or like trying to relicense a photo commercially. Then there's attribution non-commercial share-alike, kind of a mouthful, but it's the same principle, but of the last two, but just combined. So not only can't use it commercially, you can't use it commercially, but if you release another version, you have to release that version under this same license. This is actually really popular with musicians. A lot of musicians release like musical stems, and I'll get to that in a bit. Next is attribution no derivatives, which says you can't make a modification of this. And then finally, just a shade away from actual normal all rights reserved copyright is attribution non-commercial no derivatives, which means you're basically only allowed to share it non-commercially and you can't make modifications. Whew. Any questions before I kind of talk more about how CC does this? Okay, so the idea is to offer these licenses to the public in an easy to kind of understand user interface to copyright law. We're not replacing copyright law or even really substituting for it. We're simply clarifying it to the extent that you get like a bundle of rights in copyright. Using a Creative Commons license helps you specify to the world what rights you want to keep and what rights you want to reserve. So if you go to our website and you go to license your work, it says allow commercial uses of your work. You can say yes or no, allow modifications, yes or no. And then you have additional information where you can fill out kind of interesting information about your work. And then you kind of get something that looks like a YouTube embed code, but instead of it being a video or a photo, it's the license itself. And by doing that, you're licensing the web page or whatever you're pointing to under a Creative Commons license, and that's kind of bound to the legal deed itself. Yeah?
If someone's released something under a certain license and then decides kind of changes his mind,
right,
wants to add or remove permissions, is that possible?
That's a really good question. So Creative Commons licenses are perpetual and irrevocable. And they have to be in the same way that the GPL is, because you don't want to allow people to kind of seed the commons with something that's really good. And then once, like, you know, Time magazine starts using your photo on the cover, you can then sue them. I mean, the basic functionality of the license is broken at that point. What you can do is simply stop offering it under that license. You can actually go on Flickr, which uses Creative Commons, I'll get to that in a bit, and change the license whenever you want. What it means, though, is that people who may have accessed the work under a Creative Commons license at the time, when you had released it that way, still have the right to use it under those terms. You're not really kind of nullifying anything. You're simply just removing it from the commons.
So does that mean that the service on Flickr has a history of
no, it doesn't.
When it had a certain license?
This is, in theory, Flickr has this somewhere in their database, but somebody has made a third-party tool, which I'll show you. It's, I just used it recently. It's really cool, called Image Stamper, which you can use to timestamp images. So people can't reverse on you. You can say, listen, I have somewhat good proof that this person licensed it this way at this time.
People could cheat by taking it from somewhere that took it at then, and you know, that is sharing alike. Supposing someone took it and then is sharing alike, and then they take it from that site. See, it's once the genie is out of the bottle, surely there's no way of putting it back in.
Yeah, but you know what? We haven't really found that many situations where somebody's like stopped offering a work under Creative Commons, and then the person's gotten angry, or like nobody's ever like really. It's never been an issue.
Accidentally, you know, put it Creative Commons.
So one thing that's really great about Creative Commons, and it's one of the things that as a geek I get the most excited about, is that we offer the licenses in 3 different formats. And the GPL was originally just a text file that got included with the source code for applications, but CC licenses are actual documents on the web that live there permanently. And this is a human-facing, or human-readable deed. And then we have the lawyer-readable legal code, which enforces the kind of terms of the license. And then we kind of have the like rich semantic metadata. And the metadata stuff's really important because it allows search engines to crawl for Creative Commons licensed work. You run a search engine at search.creativecommons.org where you can just look for Creative Commons licensed stuff. And this is all possible without like humans picking through each one and say, hey, this photo's licensed this way and this photo's licensed this way. It's possible because when you choose a license, you're also expressing to computers what the terms of that license are. And I can talk more about that later, but I have a feeling I'm going to run out of time on this talk, so I'm going to skip the kind of like obtuse metadata talk section. So I'm a photographer in the other half of my time. This is one of my photos, and just if you go to fairbenenson.com, you can just see that I eat my own dog food and also license my work under Attribution Share-Alike. And I have some fun stories about that too. Another great part about Creative Commons is that we have jurisdictional projects in 47 different jurisdictions, and we're working on 9 more this year. This means that we've ported the licenses not only to the language of, let's say, Brazil, which is Portuguese, but to the legal code and wrinkles in Brazil. And it sounds really cool, but then when you really think about it, it's like mind-bogglingly cool, because if you saw that map of the Berne Convention, that was as close to synchronization of copyright laws in my last talk that we'll ever get. And Creative Commons is kind of leading the effort in an open way to synchronize the kind of wrinkles between, let's say, France and American copyright law, or Brazilian and Chinese copyright law.
Is the functionality in all these countries exactly the same? In other words, is it fully portable?
The idea is for that to be the case. As we've been on this roller coaster of a project to get this to work right, we found issues that look difficult and we're still working on. They don't relate necessarily directly to the Creative Commons licenses. The idea of putting something in the public domain is not possible in Europe. So there's another project we're trying to work on that allows people to waive all rights to a work, which I'll talk about in a bit, but that is one of the more hairy problems. There's another issue with mandatory licensing societies in Europe that we worked around and that kind of thing. But the basic argument is that the licenses are portable and useful across jurisdictions. So to that extent, it's kind of a huge effort. Yeah?
Why is it not possible in Europe?
So I should have mentioned this in my copyright talk, but it's a long story. But it's not that long. Basically, Europe has something called moral rights, and it's something we don't have in America. And it's a really interesting difference between American copyright law and most copyright law in the rest of the world. Moral rights say that you as an author have the right to be attributed properly and to not be misattributed. That kind of sounds like the same thing, but it means somebody can't go out there and start releasing Kandinskys if they're not Kandinskys. It's illegal to do that in America. You can actually do that. You may be committing fraud when you're telling somebody it's a Kandinsky, but if you put a signature that looks like Kandinsky on something and say it's a fake, you can do that in America, and you can't actually do that in Europe. It's because of moral rights. And moral rights are actually something that tie way back to the Roman Empire and kind of longer traditions in Europe having to do with authorship. But that is one, moral rights are seen as unwaivable. So even after copyright expires, etc., you still have moral rights. And so this issue is problematic for public domain waivers because you can't say, I waive my moral rights. And there's a workaround. Well, it looks like that you can't do that. And there's a workaround that we're working on that says, to the extent possible, I'm not going to act on these moral rights. So it's not quite the same as a waiver. But lawyers can spend all day arguing about this. And they do, and it's one of the fun things I get to do every year is watch all the international lawyers try to come to terms with this stuff.
Question. When it says generic when you're doing that selection, what does that mean?
So generic is for American U.S. copyright law, and we kind of have the unfortunate, we're kind of in the unfortunate position of being the world's copyright bully. So the idea is that if, not Creative Commons, America that is, the idea is that if you don't have a Creative Commons license jurisdictional project in your country, you can choose the unported license and kind of assume that it will work for you. And so it's both American standard Creative Commons license and the kind of unported license. So that's what that means. If you go to the license chooser, it'll
but if you choose a United States license, that means that that license only applies to other people in the United States, so people in other countries can't use it?
No, it applies to people in the Berne Convention kind of swath. So that's all but a couple dozen countries probably. This is the projected growth for hundreds of millions of objects on the web licensed under Creative Commons. We're now 7 years old, so it was kind of too small to even put on the graph when we first started. But we're now at least 130 million objects on the web licensed under Creative Commons. It's probably going to be more. There are at least 75 million on Flickr, which is this, yeah.
Do you have any indication of percentages?
So I was told that it's not quite exponential.
No, I'm saying percentages, 130 million. Do we know the total number of objects on the internet? I know someone found at the end of it.
This is the kind of guess. This is the conservative guess of the total.
What proportion?
130 million objects are CC licensed.
Right.
Out of?
I don't know. That's a good guess. Ask Google. It's probably vanishingly small. I mean, like you think. You look up like the word. I don't know. You look up like O.J. Simpson. He was in the news recently. He probably gets 86 million hits. I don't know. Somebody do that if you're on Google. I'm curious. But that's changing. And in terms of the web is so difficult to measure because it's so big that we've had consistently difficult time estimating this, and so now we're kind of like forced to have to be incredibly conservative. The number's probably a lot bigger than this, but it's very difficult to get the right answers from Google and Yahoo because their catalogs are hundreds of billions of objects, right?
6.6 million for O.J. Space
Probably some of it Creative Commons licensed. Anyway, this is what Creative Commons looks like on Flickr. They're one of the coolest kind of early implementations of Creative Commons. When you upload a work to Flickr, you can choose what license you want it to be under, but they also do this really great exploration feature where they break it down by license type and they show you how many works are licensed under that particular license. And so you can search, give me all the New York City photos licensed under attribution. I need to use them in a car commercial or something. You can just get it off Flickr, and whether you'd be using photos in a car commercial is another story. But at least 75 million photos on Flickr, which is a pretty good percentage. This is kind of what it looks like. just looks down in the bottom corner there. It says some rights reserved. You click that, and then it takes you to the human readable deed, and then you can click through and get to the legal license. So everyone always asks me about Creative Commons like testability, or whether or not it actually works in court, because in some way it's just a big guess whether it's a big hypothesis on the way a license could work. Most licenses are private. It's between me and Evan. I'm saying, Evan, you have a one-time right to use my photo. It has to be in this context, and that's it. You can't sublicense it, you don't own it, whatever. With Creative Commons, I'm saying the general public, anybody who comes across it. So there's this question of legal tenability. So this guy's named Adam Curry. He's rumored to have invented the word podcasting, but that was also on his Wikipedia entry, which was also edited by him. These are photos of him on vacation with his family. He's kind of a big name in the Netherlands, and somebody at some tabloid paper picked up on these photos on his Flickr account, saw that they're under Creative Commons license, and published them. But the thing that they didn't pay attention to was that it was actually under a non-commercial license. You can see here it says this photo is public, and there's a little CC license. Flickr was counting on you to know what that Creative Commons thing meant. They've since changed it to the individual license icons, and they moved the photo as public thing. But the argument by the tabloid was that, hey, it says the photo is public, that means it's in the public domain, we can do whatever we want with it, which totally sidesteps like very important other legal questions about their right to use a minor's photograph in a tabloid without her permission, etc. But it was great news because they found in our favor. The court basically held that the Creative Commons license, the Creative Commons license photo, because it was licensed under non-commercial, it was used in a commercial context. They broke that license. They had to stop doing that, and I think they also reached a settlement out of court. So this was kind of like one of the big first early tests of Creative Commons licenses, legal viability. Before I move on, I should talk more about another court case that's so much more significant than this. It's silly that I don't have it in here, but it's not very interesting, and there aren't any visually interesting. There aren't many good photos about what happened, but there was recently a lawsuit over whether a certain model train software company could appropriate source code from another model train project and use that source code without abiding by the terms of the license. The license wasn't actually a Creative Commons license. It wasn't the GPL. It was the Perl artistic license, but it was an open source license, right? So they went to court. They were battling back and forth. Some people in the free software world were like, you shouldn't do this because if we lose this one, then it means our licenses don't work, and that's really problematic. But they originally, I think, lost the case, and they appealed, and then the federal level circuit of a court of appeals, the Ninth Circuit, which is the intellectual property circuit, found in the favor of the license being valid. And they specifically referenced Creative Commons in a number of paragraphs in the opinion, saying that these open source licenses really help cultural development and help people to collaborate on projects. And this was only a week or two ago. I guess now, at this point, it's about a month ago.
What's the name of the case? You know?
What's that?
Name of the case?
I think it's Katzer versus Jacobson. I'll definitely put a link on it on the wiki, but it was incredibly significant. So it validated all of the legal theory that Creative Commons and the GPL and all these other projects are based on. Anyway, we have a number of other projects. Two of our most recent one is CC Learn, which is an open educational resource project. The idea is to help people kind of collaborate and work on individual projects in the educational space, also using Creative Commons licenses, but maybe not necessarily. We also have Science Commons that's attempting to establish these norms on a non-copyright level, on levels having to do with human genome data, patentable scientific processes, and that kind of thing. We kind of have a lot of other projects, but I'm going to kind of skip towards the more recent and interesting one. One of the things we launched about half a year ago was CC+. This allows people to specify rights outside the scope of a license, so that if you're a musician and you want to be able to release a work non-commercially, but you also want people to know that they can contact you if they do want to use it commercially. You can use CC+ in conjunction with any other license to just say, here's my contact information, here's a commercial agent that's get a license or rights, or here's my broker. And there are people now doing this on MySpace. So if you find this guy's named Gary New Vision, you can go download all this stuff under Creative Commons non-commercial, but if you want to use it commercially, he's signed up with a service called Pump Audio that automatically negotiates commercial rights to music, and they rent out these big hard drives for commercial advertising firms to listen to music to include in commercials or whatever it is. And then when you want to use that, you kind of do a deal with Pump Audio, and then Pump Audio splits it 50-50 with the artist. But CC+ is meant as a protocol to allow other private licenses to be tacked on to Creative Commons licenses. And that's really popular right now. So this is what it looks like. It says you add some Creative Commons, or in that little beginning part where you fill out the license chooser, you put a URL for permissions beyond the scope of the license, and then it shows up in the actual deed itself. This is what it looks like in terms of the RDFA. This is what Pump Audio looks like when you hit it, which is pretty cool. One of the cool things, and this is for record industry types, is Creative Commons in Denmark worked with the Collecting Society, which is a rights organization that collects fees for songwriters and musicians when their work gets played in public. In Denmark, the Creative Commons project there worked with the Author Society there so that artists can release work non-commercially, but also still get income from like the equivalent of ASCAP, if you're familiar with that. So this is a band called Tone. I actually like them. You should download their stuff if you want. And it's under a non-commercial license. Gemendo is a site based out of Luxembourg that is kind of based on a tip jar philosophy, but they offer everything online to be downloaded for free under Creative Commons, and now they're at over 11,000 albums. R. Kelly used our licenses for a couple remix contests, kind of wild. There's a site called Jam Glue that like specializes in Creative Commons licensed kind of remix contests. Oops, wrong way. Public Library Science is an academic journal that's trying to kind of take down the publishing cartels that extract massive amounts of fees from universities and students and graduate students for getting access to academic journals. PLOS ONE is a nonprofit that uses the most liberal Creative Commons license, but they do it all in one place. They started off as kind of multidisciplinary journals like PLOS Biology and PLOS Medical Sciences, but they've since kind of merged it into one big content site for the purpose of kind of trying to get scientists to work together. So you can see recently published here, it says, from offshore to onshore, multiple origins of shallow water corals, and that's mixed in with a female chimpanzees, etc. And they'll basically publish it as long as it's real good science, and it's under the most liberal license. Their biology imprint is ranked the highest impact factor, so it's kind of the best science out there using open access, and that's part of the open access movement. There's Lulu, which is actually based out of New York City. It's a self-publishing company. You can upload your stuff and release it under Creative Commons, but you can also sell hard copy versions of it as well. You guys know Nine Inch Nails releases his most recent 2 albums under Creative Commons, which is really cool, under non-commercial share-alike, allowing his fans to kind of remix stuff. But what was great is he did this really cool tiered pricing scheme where you get the free download, which was the first 9 tracks, and his MP3s. $5 would get you all 36 tracks, and it kind of going up. But the best part was this is $300 ultra deluxe limited edition package, which he like signed and hand numbered, and it came with like 4 DVDs of uncompressed audio and books, and like just total like, if you're a Nine Inch Nails fan, this is like probably the coolest thing ever. And he sold these out immediately, just like in 2 or 3 days. And then later, oh yeah, had also put it on Pirate Bay. And I took this screenshot recently, and there's still a dozen people downloading it with hundreds of people seeding it on Pirate Bay. And it's all because it's under Creative Commons license that this is even possible. So he went on to make at least $1.6 million in the first week, which is kind of wild. And who knows how much more he's made. This is, you know, immediately after it happened, so he's probably still raking it in. He's gone on tour, and obviously he's a popular artist, but a lot of people are like, oh, Creative Commons is interesting if you want to kind of get your name out there, but you don't want to make serious money, but that's not the case. You can definitely make money releasing your work under Creative Commons. It's all just about leveraging the notion of a free copy. Speaking of free copies, this is Free Culture, the book that is kind of similar to the book code that you're reading now, and kind of inspired me to get involved in this whole stuff. It's also written by Lessig. This is my club. This is a number of years ago. That's Stallman wearing a sandwich board. It was kind of a wild night. We were protesting Tower Records, which is now gone. It was on that corner over there. They were selling Drm CDs.
I'm still pissed off you waited for me to leave to take that picture.
You left? I have another photo on this stuff. It's not in here, but I think, did you figure it out? Somebody else figured out that they were selling the CD that had a virus on it that the record companies had put on there to prevent people from copying stuff. And I don't know. It was a fun night. So Wikipedia is also free culture. They use something called the GFDL, which is a public license made by Stallman for software manuals in the 80s, but it's basically the same thing as Attribution Share-Alike, except for it's sadly incompatible with it, but that gets into license technicalities. So Linux is also free culture, but freeculture.org is kind of the student movement that I'm involved in. We also call ourselves Students for Free Culture. I'm no longer a student, I'm just kind of on the board and kind of still helping out on various projects, but we have a manifesto which was kind of sadly written a very long time ago by the people who were involved in that Swarthmore thing. I think the manifesto is kind of a funny thing to call it now, but you should take a read if you feel like it. We have chapters in dozens of universities around the country, and that's growing all the time. It's kind of a fun project to kind of connect with other people who are interested in these topics on campus. The basic idea is that we want to advocate for more free culture, discussions around these topics. People are interested in kind of copyright. There's kind of a whole world out there, and there's a lot of work to be done. I kind of see it as a new political movement that people should really think hard about, because these are decisions that, whether you know it or not, you're already making about how you use media and how you interact with media. And you might as well be doing it in the right way. So this is the website, freeculturenyu.org. If you're interested in kind of participating, the group of kids running it now are really awesome. It's just been fantastic to see them kind of take off from where I left it in a way. This is kind of an old post, but we do a lot of screenings. We do a lot of outreach, stuff like this. I think the first event we did was in this room. We were screening a film called Night of the Living Dead. Obviously, you guys know that film. But it's funny because it was one of these films that nobody really remembered until it was too late and it slipped into the public domain. So Night of the Living Dead's actually in the public domain, along with movies like Sex Madness and Reefer Madness. And a lot of these are kind of non-Hollywood films, right? I did a lot of research into this stuff. And I think Night of the Living Dead was done by a director who wasn't really affiliated with that kind of Hollywood cartels, and so nobody really thought about retaining the rights properly, and there's some confusion over who actually owned the rights. And so there was this big switch before the '76 Act went into effect that if you didn't kind of reapply for copyright, you would lose it to the public domain. So I thought one of the first things we could do was just do a screening of it. And I don't know if you've ever tried to do a screening at NYU, but they actually say you can't do it, or you have to charge a fee, or you have to go through the program board. It's like this whole complicated thing. And it's because the motion picture industry is like, well, these students are going to be ripping us off, and we're just going to start going to NYU movies instead of real movies. And NYU is very worried about this. So they don't like it when you screen stuff. And I remember it was when I was first kind of like becoming friends with Evan. You later told me that it was like people definitely brought this issue up when we were pushing to screen it, and that was something that I wasn't really anticipating. I just kind of wanted to do it as like a stunt, like, hey, we're showing something from the public domain and that kind of thing. Anyway. Other stuff we did was kind of advocate for free software, like Firefox is free software. It's licensed under a license that's very similar to the GPL. that allows you to kind of work on it yourself, and it's part of the reason why it's a better browser. There once was a Linux user group on campus, and I don't think there isn't anymore. So universities are really good places to talk about these things because it's really a place where you kind of forget about copyright involved in terms of your personal growth, right? I mean, getting access to culture and building on things and putting things out into the world, you're really thinking about how you can monetize that. Unless maybe you go to Stern, but then you're not thinking about that until afterwards. But when you're undergraduate and you're on campus, it's kind of a good time to think about creativity and the notion of the commons. And I always thought it was like a really interesting potential for a real political movement about sharing and advocacy for content online. So this is just some kind of highfalutin stuff that I put in here to help justify Creative Commons free culture for other people. But I feel like I'm kind of losing my voice. The one thing that we did do that got us a lot of press was Drm Protests, and nobody had ever protested Drm before. So do you guys know what that means, what Drm is? Yes, no? Give me some sign. Yes, a little bit. Okay, well, Drm stands for Digital Rights Management. People like to antagonize the term and call it digital restrictions management. But that doesn't make as much sense, and it's not actually what the record companies called it. Drm was meant as a way to force digital media to behave like traditional media. So when you buy a CD, you couldn't copy it easily. Like, it would be difficult to copy a vinyl record. The record companies wanted to make it that difficult to copy a CD. And that's actually really problematic because there's so much hardware out there that makes it very easy to copy CDs. You could also just turn it into other formats like MP3 that's, uncontrollable. So, since I have a little bit more time, let me just explain why DRM will never work. And it's not some like ethical argument. It's actually kind of a basic computer science argument. You guys are doing encryption, so this is the perfect time to talk about this. So with encryption, you have two people, right? Like Alice and Ben. And so they're trying to communicate.
The encryption homework's due tonight. Don't give away too many attempts.
All right. It's not going to be a giveaway. I mean, maybe if you guys know about.
I'm just kidding.
Whatever. Okay, so they're trying to communicate, right? And in a normal world, they are open for other people to hear. So this communication is open for other people to hear. It's like a conversation we're having in this room. But on the internet, it's even more exposed because there's like thousands of servers that are in between here, and they're all getting a copy of each message, right? So if there's any time Carl wants to come in and look at what they're talking about, he can just go to one of these servers and transfer the data back and see what Alice is telling Ben. Right? Got it? So that's the basic justification for encryption, is if Alice and Ben in advance determine a way to communicate with each other, like I'm going to say X when I mean Z, and Z when I mean X, or something like that. If they agree on that beforehand, then when Carl overhears the message, he's not going to know what they're talking about, right? So in a way, it prevents people from snooping on the line. So this all has to do with DRM, because DRM is making a basic assumption of how this works. Carl is the attacker, right? And these are the two parties that are trying to transfer a message. And this makes sense. Encryption works well in this capacity. I'm trying to think if I have a bit more space here. Let me just fix this. Okay, so let's go now to how DRM sees the world. So say you are Alice, and you're in front of your computer, and your computer, you're Alice at the record company, your computer, you're Ben, you're sitting at your computer, and you want to access the data from the record companies, right? But the record companies don't want you to be able to decrypt that data. They don't want you to be C. right? But the problem is, there's no way for you to both be B and not be C at the same time. Because if you, I'm sorry, I'm getting some of these. Hold on. I'm making this far more confusing than it has to be. But if the record companies also assume that you're C. Okay, this is the basic premise, right? They don't want you to take a CD and turn it into an MP3. So they also assume that you're the attacker, right? Which doesn't make any sense because you're both the recipient and the attacker. So they can't give you the keys in one hand to be able to listen to a piece of music or watch a DVD or watch a Blu-ray disc, but also assume that you're to be the one decrypting it, because in some ways you still have to access the data. So the record companies are assuming that you're both the recipient and the attacker, as opposed to in a normal traditional encryption scheme where there are 3 parties, and the attacker is some other third party. Does that kind of make sense? It's kind of an esoteric way of saying why DRM doesn't work. And DRM, the whole principle behind DRM is that they're going to lock something up and make it so difficult for you to decrypt it unless you're only watching it, that it's going to be not worth your time to actually decrypt it. So the one other twist here is that if anybody comes along and breaks the lock is broken for everyone. This is what that 14-year-old Norwegian kid did, right? He figured out the encryption for DVDs, posted it on the internet, and then started distributing, and then that started getting distributed in things like magazines and Usenet forums and that kind of thing. And suddenly the whole DRM scheme was totally broken. So DRM is fundamentally broken in this capacity. There's no way to control digital media. And as soon as something shows up on iTunes, which uses DRM, it shows up on the Pirate Bay or other BitTorrent sites in 8 to 10 minutes, I think is the current average. Same with movies, same with, I don't know, pick any other format, and it's easily available for free in an unencrypted format. So DRM will never win. And we see the record companies are actually coming to this conclusion. They've kind of admitted this. They've stopped trying to apply DRM to CDs, and they've started kind of doing crazy stuff, or stuff that they originally thought was crazy, like selling you MP3s. Does anybody use an Amazon MP3? Yeah, I like it a lot better. I use it constantly. And it's basically an easy way to buy MP3s, and like I have no problem with that. It's a format that I can use. I've never bought DRM stuff, and I don't think I ever will. It's kind of a dying attempt for music, but it's a little different for video. So this is all to say, this was kind of on my mind when I was starting Free Culture at NYU, and one of the things we ended up doing was protesting DRM CDs being sold at Tower Records and Virgin. And this got us a lot of press. It was cool. We got written up in USA Today and Rogue's Voice and all these other places. And it turns out nobody had really protested DRM in the same way before. Stallman went on, because he came to one of our protests, he went on to create an organization called Defected by Design, whose sole purpose is to protest DRM. And every so often we kind of join up with them. Free Culture.
Stallman founded that?
Yeah. Well, I mean, he told the Free Software Foundation to do it, but it was only after our protest. Somebody actually figured that out and put it on the Wikipedia page, which is very cool.
Someone named Fred?
No, not me. No, that's what's so cool about it. Free Culture Columbia did some really cool stuff. They gave away, you guys have map right here, like map courses still. So you're basically studying Western civilization there, and a lot of those books are in the public domain. And Columbia has a similar thing. So what they did was they found all the works that were in the public domain, put them together on a jump drive, and got a grant to buy a bunch of jump drives with the Free Culture logo on it, and then distribute those. And it was kind of like this wild feeding frenzy, apparently, and there were hundreds of people like trying to get these. And I don't think they've done it again recently, but we're doing a conference this weekend. I'm about to fly out to Berkeley because I'm organizing this. We have lots of speakers. Leslie's giving a talk, Pam Samuelson's giving a talk, CEO of Firefox giving a talk. We have a lot of panels. If you guys are in Berkeley this weekend or want to go, you should go. It's going to be awesome. We have hundreds of people registered. We get a pay what you feel for the registration system, and it's averaging around $25, which is pretty cool.
Be a webcast?
What's that?
Will it be a webcast?
Yeah, it's going to be broadcast live into Second Life. All of it's going to be video recorded and put onto iTunes University which is a partnership with the Berkeley, which is fine, but we're also going to put it online at some point too. This is something we did recently. Wiki's taken had, and I think Matt assigned this as one of your projects, right? We went around and collected.
Did anyone do it?
I don't recognize anyone. Yeah.
Apparently I undervalued it. I only gave it 1 point for showing up.
Oh yeah, it was an awesome day. I had a great time. I actually drove up to the Bronx and went there, but a lot of people stuck around in Manhattan. And the idea was you take photos to see Wikipedia for pages that don't already have free content associated with it. So Wikipedia is incredibly conservative about the stuff that they let on there, and they only choose the most liberal licensed, Creative Commons licensed photos.
How many photos did you guys post on Wikipedia?
The first time we did it, we had over 1,000, and we're at a couple thousand, so we're still uploading them, basically. Basically, we want to upload as much as possible. The Wikimedia Foundation is like, you know, as long as they're not duplicates, basically, upload them. So not quite the same as Flickr. Wikimedia Commons is the back end. It's the media back end for Wikipedia. And so that's where we're pushing all the images. It was really fun, and the prize was dinner with Jimmy Wales at Pure Food and Wine. So this is a Drm Protest we did at some movie theater a year ago.
Is Jimmy a vegetarian?
No, he suggested it though. But it's a cool place if you've ever been there. So, all right, that's my talk. I'm running out of voice. Do you have any questions or ideas? We're almost out of time. Yeah.
Well, this is about photographs. If I've taken a picture of somebody, let's say it's a person or a celebrity, I technically own the picture, but would Wikipedia accept that?
So
where does the
Wikipedia? Yeah, Wikipedia discourages using photos of people when it's not necessary. Like if you want to go take a photo of a park and it happens to have people on it, they'll choose one that doesn't have people on it. But if you go look up like some movie star or something, you'll see a blank spot for somebody. They'll say, "Do you have a freely licensed photograph of this person?" And so if you do, you can upload it to Wikipedia and they'll accept it.
You mean they have a policy that the crowd should choose one and not the person?
Yes.
There's no just like with the content, it's generated.
Right, it's community filtered in that sense. But their basic idea is they don't want to involve people's personalities when it's not actually necessary, right? So, because this has to do with publicity rights, this is another thing. Despite Creative Commons having to do with copyright, there's another kind of set of rights around people's personality. It means I can't, despite a photo of you being licensed under Creative Commons, even the most liberal license, I can't take it and then put it in an advertisement for like underwear or something, because there's actually a privacy right there in your kind of your right to say, I don't want to be affiliated with a commercial product or an advertisement that I'm not comfortable with. And it's something we're kind of aware about and we're trying to work on, but there's only so much you can do when you work with copyright licenses. Name somebody who's like relatively obscure but would have a Wikipedia entry.
Mitch Hedberg.
Yeah. Because, so the problem with him, so interesting thing with Mitch Hedberg is he's dead now, right? And Wikipedia will actually allow under fair use an image that's not free of somebody if they're dead, because there's no way to get a freely licensed image.
I've had a case where I put up a picture on Wikipedia of someone and they hated it. They hated the picture and they kept removing it and I kept putting it back and they kept doing it anonymously. And so I said, what the hell? I put it back up. It's a free picture. And then eventually he wrote a comment saying, I'm the subject and I hate this photograph. And I said, okay, fine. You should have said something.
Tyranny is in every community in Wikipedia. So no photo of Mitch Hedberg. So if you have a photo of Mitch Hedberg, you should definitely upload it. I actually have the photo for Tonka beans on Wikipedia. Anyway, we have other questions. You guys,
I have a question which is, with the question of resolution, could you put up a low resolution photograph and release that under Creative Commons and still reserve the rights to the higher resolution photograph?
No, not the work itself. It's problematic because Creative Commons can't answer this question because it's a larger legal question over the nature of a work. What is a work relative to copyright law? Is it every single resolution version of the work? In some sense, yes. So in that way, licensing a lower resolution version of the work probably obligates you to allow the person to use the higher resolution version if they happen to come across it. So it's your obligation not to.
And what if you take a photograph of a work, say an artwork? Could you Creative Commons license the
So, an important part about copyright law is the notion of the merger doctrine, but there's also this issue surrounding public domain works. When you take a photograph of a painting, oil painting that's in the public domain, or you use a digital version of an oil painting that's in the public domain, or is there any copyright consideration? And this is another international wrinkle problem, where in America, what's called slavish duplication is not protected by copyright law. So if you just take a two-dimensional photo of something that's in the public domain, you don't retain copyright on that. But to the extent that the original work may be copyrighted, you are making a derivative work and you shouldn't license it unless you had the ownership of the work. Sorry. Looks like you guys are ready to go.
Yeah, 5 minutes.
Yeah. Okay. You got 5 minutes. Don't go anywhere.
So I don't know if you ever got a chance to read the Tragedy of the Commons, and I'm kind of playing devil's advocate with this, but what incentive?
Andrew Keene?
What?
Andrew Keene?
No, Adam Smith, right?
Okay. Oh, yeah. Right. Sorry.
Anyway, what incentive does a person have to, whatever he takes from your Creative Commons to, put it back on into Creative Commons? He could just use it for himself. I'm sure you haven't encountered that problem right now.
Right. This is the essential question between permissive licenses and copyleft licenses. So our attribution license is just use it so long as you give me credit. You are bound to give me credit, but if you can actually gobble it up and put it in some product and not have to share those fruits with the community. And then there's the copyleft camp that says, no, if you use this, you have to release the new version under the same license and keep it sharing. And so this is a fundamental split in not only the free software community, but the free culture community. It's been a battle that's been going on for a really long time. So to the extent that copyleft licenses try to address the tragedy of the commons, I think they do a good job of it, but it's not always appropriate. And they're, Google, for example, is releasing Android, the phone operating system, under the Apache license, which is one of the larger, more popular permissive licenses. And Google's doing this, and they haven't chosen the GPL specifically because they want other corporations to come in and be able to adapt Android without having to give out their modifications, their source code, that kind of thing. They think it's more popular. It'll be more popular and more successful that way. So it's a very, very contentious battle between those two arguments. Sorry.
What is the biggest problem with DRM, and do you have any sort of proposed solutions for how to fix it?
No, I think the biggest problem is my confusing example.
Well, it's kind of how it doesn't work.
Right.
Are you saying that you just are not for any sort of digital rights management?
Yeah. Creative Commons licenses actively say you cannot release a work simultaneously under Creative Commons while putting DRM on it. You can release it in parallel, but you can't actually say, I'm putting DRM on this Creative Commons license song.
If there were no Creative Commons, though, are you supportive of DRM at all?
No, I think that the basic technical assumptions that DRM makes are broken, and it's just a clear problem. As soon as one person comes up with a crack for it, then everyone kind of has the keys to every bank. So there's a larger, more abstract issue about the nature of digital computers in that they depend on the ability to copy media. And in that capacity, I think it's just a purely technical reason why it will never work. But there's also an ethical reason. I think when Sony says, all you can do is watch this movie, that's a lot different from how it used to be. And you used to have actual fair use. DRM will never be able to figure out what a fair use is, right? Computers are dumb in that capacity. They'll never be able to say, oh, well, it looks like you want to use this movie in commentary for a news broadcast. I'm going to let you get away with it this time. It's all or nothing. So in that capacity, it's making these really crass decisions about fair use on behalf of kind of the consumers that have access to it. And it's implying that the only media relationship there is between producer and consumer. And I think that's a really, really horrible way of looking at culture.
I think it's a perfect example of how computer code is going above and beyond legal code, which is what we've been talking about the past month. One of the things we've been talking about recently in this class.
The failure of DRM.
From Lesson's book. The fact that there is this concept of fair use, which can't be encoded in the computer code, but it's in our legal code. It's a gray area.
Right.
Computers don't generally have a gray area. unless you introduce randomness, which is not what the gray area should be.
Sorry.
Is there do you have any sort of solution to prevent peer-to-peer file sharing, or are you completely for peer-to-peer file sharing?
You know, to the extent that people see it as a good thing, I'm totally for peer-to-peer. Like, I'm not going to go encourage you to go like find things that you should ordinarily pay for on peer-to-peer networks, but I think it's an absolutely viable way for people to distribute their media. I think it's absolutely great. I mean, it's ideal. It's reduced the transaction cost and the distribution cost of acquiring media to almost nothing. And that's taken thousands of years, but the fact that we have culture available at such ease is hopefully it'll be looked back upon as a great moment in human history, not something that should be locked down, right? I mean, that's my biased opinion, but you don't have to agree with me. It's not nice. Yeah.
Is there any way for collectors to track derivatives of their work?
It's a great question. There's a site called Attributor that I learned of recently, where you can upload your stuff and it just basically crawls the web to find uses of your images and in video. And so like we kind of see this as like a good thing in some ways, but maybe not all the ways. I mean, they definitely want you to go like gouge people for using use of your work and then give them a cut, or like Condé Nast uses it and all that kind of thing. But that's kind of like a larger technical problem that third parties are now trying to solve, like Attributor. So, I mean, it's never going to be perfect though, right? Like, you're either okay with sharing your work and kind of losing a little control over it for the sake of like getting better exposure, or you're not, and then you just don't put it on the web.
Well, just like from a creative standpoint, to see like how it's evolved. So this only really tracks it if it's back at that.
Flickr, like if you go into Flickr, I'm gonna have to log in. I don't know if we, I guess we're running over time. All right, that's it. But Flickr will show you statistics for photos and who's linking to it and that kind of thing. And Google also really works well. You just Google your name. If they've given you proper attribution, then hopefully you should find it.
One question: have you ever thought of actually making tags that could be incorporated into media, directly into the media?
Yeah, one of the things I kind of skipped is that a lot of files out there contain metadata stuff that you can put Creative Commons into. It's a really vague thing, but think of files as containers and then metadata as the label for the containers. You are actually able to now tag things like sound files like MP3s and PDF files with Creative Commons licenses, so that when they get copied across networks, they can retain that license information.
We have no class on Monday because it's Columbus Day, and thanks, Fred.